Yeah.
So,
Yeah. In fact, let me take our viewers through a summary of what all has happened right now. Firstly, because the hearing is currently ongoing in the case, there are 5-6 points that have been discussed. The Solicitor General has said that the meaning of public servant should be seen in context by giving examples of police or army personnel committing offences while on duty, which attracts aggravated charges. Then the SG has also argued that the POSCO borrows the definition of a public servant from the IPC, but the phrase unless the context otherwise requires and allows contextual interpretation. Remember, section 5 over here is being discussed of the POSCO. Then the Chief Justice of India has noted that the SG's argument treats a public servant as someone in a dominant position at the time of the act, such as an MLA exercising influence when approached for help. The Tushar Mehta has then said that even if the accused is not treated as a public servant under section 5, the act which he has committed will still fall under section 3, and the amendment will only attract enhanced punishment. That is what is coming in right now. Then the Chief Justice of India has observed that the amendment reflects legislative intent to take such offences seriously as being against the ethos of society, which guides courts during sentencing. In fact, Tushar Mehta has also referred to section 42A of the POSCO Act, said the High Court did not consider it and urged the court to stay the order in the interest of the child victim. Let me go across also to Advocate Tanush Dikshit, who has also joined us on the broadcast. Thank you so much, sir, for joining us on the broadcast. We are looking at this hearing that is currently underway in the Supreme Court. We have listed some of the points that are being discussed, specifically section 5 of the POSCO Act and how it is relevant in this entire case. In fact, Tushar Mehta has stated that even if section 5 is not relevant, section 3 is, and the amendment then attracts more punishment in this case, sir.
Yes, hence we all know that this case was started in 2017, and it's already that Mr. Sengar has been convicted for under the section 376 subclause 2, also under the POSCO Act Section 5, which imposed that the minimum punishment should be of 20 years of a span of time and maximum for a biological life throughout a life. So that does mean that this bail cannot be retained at this point of just on a 10 year span of a 7.5 years. So this indicates by the Honorable Tushar Mehta in the Supreme Court that this case should not be taken in this matter to be stay on the sentence of this just judgment. So it has to be and here in the by the Delhi High Court. It is again to be it is under hearing in the Supreme Court also.
Right, yes. Right. In fact, let me just, I'll come back to you, sir. We have some major update that is being coming in from the Supreme Court. The Chief Justice of India has said that the matter requires consideration. We are inclined to stay the order. That's what the CJI is stating during the hearing, that they are inclined to stay the order. General principle is that once someone has been released, that person will be heard, but here he continues to be in custody. So the CJI is taking note that there is already a case in which he is convicted. He is serving 10 years in that case, and hence this matter actually requires consideration. They are inclined to stay the order. Let me in fact go across to Mr. R.K. Singh on this. Sir, we are seeing that the CJI has stated that they are inclined to stay the order, given that once someone is released, then the person is heard. However, here he is continuing to be in custody.
Yes. I am also reading it. I mean, CJI is he is saying that he is tentatively inclined to stay the order, and the reasoning which he is giving is absolutely a judicious one. Since he is already behind the bar in another case, a case related to this offense only. because CJI is under this impression, and rightfully so, that when a person gets the bail and he walks out of the prison, then it becomes generally very difficult, and it is not very judicious to send him again back to jail and by curtailing his liberty. Since he is already in jail and behind the bars for an offense which is directly connected to this offense only. So as of now, staying this order will not be a great problem for the CJI. Secondly, Shivani, we must not forget the travesty of our time, that today is the day when in 2012, a young girl called Nirbhaya lost her life to this kind of offense only. And we are fortunate that this girl is alive. Otherwise, this accused has not left anything wherein he was all intended to, he's intended to kill this girl. So this girl is brave enough and she is alive. And this is the cause of celebration, and we must join together, irrespective of whether being a lawyer or no lawyer or activist or no activist, that we must celebrate the bravery of this girl. This girl is still fighting and she is breathing. Otherwise, 12, 13 years down the line, since morning, every year and year after year, every day, in last 1 week of the December, it is very painful for people like us and people like, many people in this country to remember the horrific incident which has happened with Nirbhaya. So this is the irony of our time, that young girl who unfortunately, because of her bravery, is not being turned into a Nirbhaya, and she is there to fight for her case. And we are all standing here. And we are very hopeful. As a lawyer, I am very hopeful that the CJI is going to stay this order, and in long run, it is going to quash this order also.
Right.
Yes, please.
In fact, we also have some more updates regarding the hearing, where the Chief Justice of India is stating that there are some legal issues there which requires determination, and sometimes we are all prone to that. In fact, they were discussing what charges have been framed, because there are advocates of Sengar who are stating that charges were framed under section 376(1) of the IPC. He wants to answer that charge, and he is stating that a penal statute cannot import definition from another statute, because we have Justice Maheshwari, who was stating that the ground for suspension by the High Court was that you are not a public servant. So they are currently discussing how Sengar was a public servant or not, and that those technical issues are being discussed with over here. Let me go across to Ashwini Dubey, who is also with us on the broadcast. When we are looking at this entire ground for suspension that they have put forward by the SC, all right. Right, let me just in fact give you some more updates that's coming in. The Supreme Court is saying that it is inclined to stay the order of the Delhi High Court, and this remember that the Delhi High Court order suspended the life sentence of expelled Bharatiya Janata Party leader Kuldeep Sengar in the 2017 Unnao rape case of a minor girl. So this is the latest that we are tracking for you. They have also issued a notice to Sengar on an appeal of the CBI against the High Court order. So the notice being issued is the latest that's coming in this entire case. Let me take that across to L.N. Rao, former DCP. Sir, a notice the Supreme Court is serving based on the CBI plea. What do you make of it?
Definitely, without issuing notice and without having details from the CBI about this order of the Honorable High Court, that the final judgment cannot be done. But in the meantime, when the Honorable Supreme Court has found some relevance in the...
Sir, before, I'll just like to interrupt you. I think as we are getting the latest updates, the Supreme Court has put Sengar's bail order on hold. That is the latest that we are getting. The Supreme Court has stayed the order suspending Sengar's life sentence. Along with that, they have also issued a notice to Sengar. So that is the latest that we are getting from the Supreme Court hearing. They have stayed the order, the order of the bail order from the Delhi High Court has now been stayed by the Supreme Court. The notice has also been given. Yes, sir, please continue. Mr. Rao.
Yes, that notice with the response of the CBI in this matter, and definitely it's very good news that the Honorable Supreme Court has stayed the order of suspending the sentence, life sentence of Kuldeep Sengar. And I think that is now that response, final judgment will depend upon the response of the CBI and other relevant arguments which is to be heard on the next date of hearing. Till that, I think this stay orders has been stayed, and he will not be getting benefit of the High Court orders of suspending his sentence in this life imprisonment case. And it seems to be a good news for the survivor and the victim of this case. And they were definitely apprehending that they may be harmed by the man of Kuldeep Sengar. No doubt he is in jail, but he has all his supporters outside jail. Then they were apprehending some danger from them to their life and their dignity. And now I think after this discussion on the next date of hearing, the final judgment will come out in this case.
Right,
and,
right.
Yes.
Right. In fact, let me also go across to Advocate Tanuj Dixit, who's also joining us. Advocate Dixit, we finally have that order. They are staying the Delhi High Court order. The Supreme Court has given its verdict over here in this case. What do you make of it?
See, the Supreme Court approach has been clear that zero tolerance and no dilution of the law. See, the matter is about, it's not only about the sympathy for the accused, it is about the justice for the child victim, which matters a lot. POSCO is a special law, and IPC and POSCO both are applied in this matter, which make more stricter punishment must prevail. So this cannot be whatever the order has been passed by the Honorable Delhi High Court must been stopped by the Supreme Court, because in such manner it goes dangerous message to the society also, because it makes the weakness of the protection of the child and women's law. So it has to be like in this manner only. Yeah.
Right, right. Let me also go across to Tahira Hassan. Ma'am, we finally have that verdict. The Supreme Court has stayed that Delhi High Court order that actually suspended the sentence over there of Sengar.
I had already said that I am optimistic, because I have been working as a women rights activist in Uttar Pradesh, the biggest Pradesh of the country. I know always the women are in distress and fighting for the justice. Always the highest court of land stood with us. I am very happy. I salute the survivor, this strong girl. She took the head on most strong man of the Unnao, Kuldeep Sengar. I salute her. Our girls, our sisters must stand up, because we have our rights enshrined in the Constitution. These are the tools. We must fight against these type of goons. I am very happy.
Absolutely. In fact, let me go across to my colleague Sambhav Sharma, who's joined